So you have a great idea, an invention, a prototype, a useful design, special design of something that you're making, and you know that you need to bring in other people to help, and you want to go out and show people and tell people about it, um, and maybe bring in investors or start taking orders or just again collect up the people that you need to help you launch. Um, and the question is, uh, how do you protect yourself? How do you protect yourself from them just taking it and running with it? How do you protect your intellectual property um, while bringing in the people and showing and telling people about it? And at what point are you safe to start doing that? Because sometimes it's a chicken and an egg thing, right? You know you have to do that at some point in order to get to where you're trying to go. You need other people, and you need to be public about it. How do you protect yourself so that you can have those conversations and actually move forward? So that is one of the primary reasons that people file patent applications. You can file a design patent application or a utility patent application, depending on a lot of factors, what you're trying to protect and what you have, what's available. So you can't always get a utility patent. Like some things don't qualify for utility patent. Some things don't qualify for a design patent, and some things might qualify for both, but it depends on what you actually are trying to protect. Maybe you file both, depend if you want to protect both, the design of it or the function of it. Function being utility, design being design. But sometimes when people say the design, what they're really talking about is the function. So the words are a little bit interchangeable sometimes, and that's why it's a longer conversation, and it's not something I can give you like yes, no, black, white answers on a video without having a conversation and learning a little bit more. That is the purpose of the primary purpose and primary use, or one of the primary uses of filing patent applications, is so that you can then safely talk about it, bring people in, show it at a trade show, etc. And the moment you file your patent application, whether it's a design patent or a utility patent, it is patent pending. And then you want to make sure that you mark that when you are showing and you tell people this is patent pending, so that they know that you're covered. And so then the question is, what does covered mean, and what is safe, and what is the nature of that protection? That's a little bit of a longer conversation. I have a lot of other videos on it. I will try to touch on some things about that here. But I also want to make a point of saying that you'll hear about provisional patent applications and non-provisional patent applications. Those are both utility patent applications. The provisional and non-provisional, you don't need to get hung up on that if what you're concerned about is, am I able to then talk about it? Both of them give you patent pending. Both of them allow you to talk about it safely. Now, what do I mean by safely? I don't know what's in your mind when you hear that. And one thing to understand about patents is there's no 100% guaranteed, yes, you can get a patent on this. There's no 100% guaranteed, we did patentability searching and we saw the whole universe of possible prior art and we know that there's no prior art out there. That's a fantasy. So if you're looking for that, I'm here to tell you, you will not get that level of certainty from any patent search. And anyone who tells you or gives you the impression that you're going to get that level of certainty from a patent search is either lying to you, or they're lying to themselves, or they're just incredibly misinformed. That's a fantasy. That doesn't exist. I wish it did. That'd be wonderful. I would love to give people 100% certainty, but it's not real. And one of the reasons for that is because a patentability search only shows you the last 18 months. I have a whole bunch of videos on this, but again, back to this question of what is that safe? What does that mean, safe? With or without a patentability search. Sometimes when they say safe, people mean, could I get sued? And sometimes when people say safe, they mean, could I enforce, if someone stole this from me, would I have legal rights to go after them? Those are two completely different things. And so I think, I don't know what most of the time. Okay, so in order to know whether you could get sued, being patent pending, so showing it, and this idea of am I safe to talk about it and show people. If you're concerned about getting sued, then being patent pending is not making you safe at all. That's not, being patent pending, filing a patent application is not a defense to patent infringement. If you are infringing someone's patent, if you're mostly concerned about do I infringe someone else's patent, then before going public, or by the way, talking about it to someone is not going to put you at risk for patent infringement. It would be if you are making or offering to sell or selling an infringing product. So the whole thing about can I talk to people about it? Yeah, okay, yes, you can safely talk to people. If you're concerned about getting sued, you can safely talk to people about your invention without worrying about infringing someone else's patent. But if you want to go public and start making and showing and offer and selling the invention, and you're concerned about being safe, and to you what you're thinking safe means I don't want to get sued, then what you need, being patent pending isn't helping you at all. What you need is a freedom to operate search. You need to look at what is in the, what patent that is in force might infringe, might you be infringing. And I have other videos also on that. Now, I think that more people are, when they say, am I safe, are really saying, do I have, if I have an idea and I put it out there, I'm telling people about it, I'm showing it, and they copy it, do I have legal rights? How can I stop them? And so the answer is not, so by being patent pending, you don't have enforceable legal rights per se. You don't yet. You have potential rights, though. And so you can put them on notice that you are pursuing a patent. And if that's your concern, then a non-provisional is going to serve you better, just maybe, because it's going to become a patent sooner. And if you're in a hurry to get enforceable rights, then a non-provisional is going to get you there faster. Again, this is not legal advice. I'm giving you sort of some ideas of how these things work so that you can get a little bit more understanding, and that way we can have, or you can have with your other attorneys, a better conversation, a better informed conversation, because this whole word of like feeling of safe or protected, that means a lot of different things. Like that, your idea might not be what's in your lawyer's head. So I'm trying to give you some structure and framework to help have these conversations to get a little bit more clarity. Patent pending, you don't have legal rights, but you have potential rights. It puts everyone on notice that you're claiming that this is your invention, and that eventually, if you get your patent, you can then come after them if they're still around and infringing your patent. It's a lot of ifs, but it's not like you can enforce a patent application against someone. You can't sue someone for violating your patent application. So you're not, if that's what it means to be safe, like you want to have enforceable rights as soon as you file something, then you're going to be disappointed in a patent application. It's not going to give you enforceable rights. What it does do is it blocks anyone who's going to try to scoop you and get a patent before you. That, in that sense, you are safe. So, and this is a real thing. This has happened, and it does happen sometimes. If you go out there, so let me give you a scenario. You want to go to a trade show and show you've got your idea, or maybe you're just interviewing vendors because you need someone to manufacture it and you're collecting quotes. So you need to show them the invention because you need to get a real quote, but you're concerned that they might take your design and show it to maybe file a patent application on it and then show it to their big customer that they then sell it. So if you go to them when you are already patent pending, then even if they try that, first of all, tell them you're patent pending so that they know it's not going to work if they try that. But if they do try that, let's say they don't believe you, they won't be able to get a patent because you will be ahead of them in line, and it's first come, first served. Okay, so in that way, you are safe because you have put your foot in the line. You have staked your place in line, and anyone that you talk to that tries to do it after you is going to be after you, and you will be prior art blocking them. So that's what patent pending does. That's why it makes you safe to talk to others and start showing your invention. It may not be the perfect image of safety and protection in your mind that you would like, but it is significant. And the other thing to keep in mind is if you ever want to get a patent on this, you need to file a patent application, and your window to file a patent application will close as soon as you go public with it. And that could even just be a trade show, or the public in that sense is not necessarily doing a big giant launch. It might be a private event. It still would be public. So you gotta, if you ever want to get a patent on it, you've got to start. And I recommend that you start as soon as you can because it's first come, first served. And if you don't get there first, someone else might. So I hope that was helpful. Catherine Cavella, IP Works Law.